Dear students, I welcome you to yet another lecture on company law. The topic for today's discussion is Articles of Association. In this lecture, we shall try and understand what is meant by the Articles of Association. We shall also understand what is the binding force of the Articles of Association. We shall also understand the ways in which the Articles of Association can be altered. Dear students, for a company, there are two documents which form its constitution and its main body, which are the Memorandum of Association and the Articles of Association. Articles of Association are the bylaws or the rules and regulations that govern the management of companies, the internal affairs of the company, and the conduct of its business. The articles play a very important role in the affairs of the company. The articles regulate the internal management of the affairs of the company by defining the powers of its officers and establishing a contract between the company and the members, and also the members inter se. The articles are merely regulations governing the management, procedures, and members and have no force of law, and any provision in the Articles of Association or in the Memorandum of Association which is contrary to any provisions of law will be invalid in toto. Dear students, now let us take a look at the contents of the Articles of Association. The Articles of Association generally contain the following matters: exclusion wholly or in part of Table A, adoption of preliminary contacts, definitions, capital, authorized share capital and paid up share capital, allotment of shares, calls on shares, lien on shares, specific provisions pertaining to preference shares and to debentures, transfer and transmission of shares, nomination, forfeiture of shares, share certificate, dematerialization of shares, conversion of shares into stock, voting rights and proxies, meetings and the rules regarding committees, first directors, appointment of managing directors, additional directors, secretaries and managers, delegation of powers to the directors, remuneration to directors, meetings of boards, committees of boards, general meetings, accounts, audit, borrowing powers, dividend and reserves, indemnity, winding up. Dear students, we have to remember that the list is not exhaustive and there may be other matters that may be covered by the Articles of Association. Now we come to an important point. What is the relationship between the Memorandum of Association and the Articles of Association? Articles of Association and the Memorandum of Association are closely related, as the Articles of Association are supplementary to the Memorandum of Association. The Memorandum of Association lay down the objects of the company, the various powers it possesses, while the Articles of Association determine how those objects shall be achieved and the powers exercised. The articles are subordinate to and controlled by the Memorandum of Association, which constitutes the general constitution of the company. Thus, it is always taken into consideration that while drafting the articles, it is kept in mind that it is in no way exceeding the clauses of the Memorandum of Association. Therefore, the articles going beyond the Memorandum of Association are ultra vires. The memorandum and the articles can be read together in order to remove any ambiguity or uncertainty. For that matter, if the memorandum is completely clear, then a doubt as to its meaning cannot be raised by referring to the articles. One thing should be kept in mind, that articles in no way can surpass the Memorandum of Association. For a better understanding, Duncan, Gilmore and Company Limited Re is a classic example where the memorandum had exhaustively defined the rights of the preference shareholders, and the articles provided that at the time of winding up, the company's surplus assets after paying all its debts and repaying the share capital should be distributed among all its shareholders. It was held that preference shareholders were not entitled to share any surplus assets because their rights were to be determined from the memorandum alone, as it did not confer the right to participate on them and not in respect of the articles. The relationship between memorandum and articles has been precisely expressed by Lord Keynes in Ashbury Railway Carriage and Iron Company Limited versus Ritchie, which is, I quote, "The articles play a part subsidiary to a memorandum of association. They accept the memorandum of association as a charter of incorporation of the company, and so accepting it, the articles proceed to define the duties, rights and powers of the governing body as between themselves and the company at large, and the mode and the form in which the business of the company is carried on, and the mode and the form in which changes in the internal regulations of the company may from time to time be made." The memorandum, as it were, the area beyond which the actions of the company cannot go. Inside that area, the shareholders may make such regulations for their own government as they think fit. Unquote. Dear students, we now talk about the binding force of the Articles of Association. Section 10 of the Companies Act talks about the binding effect of the Articles of Association and the Memorandum of Association. Section 10 provides that the articles, when registered, bind the company and its members to the same extent as if they have been signed by the company and by each member, and contain covenants on the part of the company and its members to observe the provisions of the articles. Therefore, the company and its members are bound by whatever is contained in the articles. One thing is to be kept in mind, that neither the company nor its members are bound to outsiders in relation to the articles, as it is totally for the internal working of the company. For a relation with the outside world, they are bound by the memorandum. The Articles of Association are framed with respect to the internal management, the business or the administration of a company. Thus, they may be binding between the persons affected by them, but it does not have the same binding force as that of a statute. Dear students, we shall now understand the binding force of the Articles of Association on the members in their relationship to the company. In the first place, members are bound to the company to observe and follow the provisions of the memorandum and the articles in such a way as if every one of them had entered into a contract to confirm to them. All money payable by any member to the company under the memorandum or articles shall be a debt due from him to the company. Articles constitute a contract between each member and the company. This was held in the case of Welton versus Safre. In Boland Trustees versus Steel Brothers and Company Limited, the Articles of Association of the defendant company contained clauses to the effect that on the bankruptcy of a member, his share would be sold to a person and at a price fixed by the directors. On the adjudication of X, a shareholder, as bankrupt, his trustee in bankruptcy claimed that he was not bound by these provisions and he should be free to sell the shares at their true value. But it was held that the contracts contained in the Articles of Association is one of the original incidents of the shares. Shares having been purchased on those terms and conditions, it is impossible to say that those terms and conditions are not to be observed. Dear students, now we shall try and understand the binding force of the Articles of Association on the company in its relationship to the members. The articles and the memorandum constitute a contract binding the company to its members in their capacity as members, and as such a company is bound to comply with the provisions of these documents. As a result, each member can restrain the company from committing a breach of the articles and the memorandum or the memorandum which would affect his rights as a member by bringing an injunction against it. In Wood versus Odisha Waterworks Company, the articles of the Waterworks Company provided that the directors may declare a dividend to be paid to the member. After having obtained the sanction of the company at its general meeting, instead of paying the dividend in cash to the shareholders, a resolution was passed to give them debenture bonds. In an action by a member to restrain the directors from acting on the resolution, Justice Sterling held, and I quote, The question is whether that which is proposed to be done in the present case is in accordance with the Articles of Association of the company. Those articles provide that the directors may, with the sanction of a general meeting, declare a dividend to be paid to the shareholders. Prima facie, that means to be paid in cash. The debenture bonds proposed to be issued are not a payment in cash." Unquote. Accordingly, the directors were restrained from acting on the resolution. Dear students, we shall now try and understand the binding force of the Articles of Association in relationship to the outsiders. Neither the company nor the members are bound to outsiders. The articles and memorandum create no contract with outsiders, that is, the vendors, solicitors, secretaries, etc. A member is also an outsider if the matter in question is not connected with his membership rights and obligations. An outsider cannot take advantage of these documents to base a claim thereon against the company or its members, even though his name may have been mentioned in the articles, for such a person is not a party to the contract constituted by the articles and the memorandum. Thus, for instance, where the articles provided for remuneration to be paid to the promoters, it was held that the promoters had no right of action against the company. In Brown versus La Trinidad, a clause in the Articles of Association of a company stated that Y should be a director and should not be removable till after 1888. He was, however, removed prior to that date and brought an action to restrain the company from excluding him. It was held that there was no contract between Y and the company. No outsider can enforce articles against the company even if they confirm him with certain rights. In Ellie versus Positive Garment Security Life Assurance Company, the articles of a company contained a clause which provided that the plaintiff, that is Ellie, should be the solicitor to the company and should not be removed from his office unless there was misconduct. He was a member also. He acted as a solicitor to the company for some time, but ultimately the company availed the services of other solicitors instead of him. He brought an action against the company for breach of the contract in not employing him as a solicitor on the terms of the articles. His action was dismissed. Even a member cannot enforce the provisions of articles for his benefit in some other capacity than that of a member. Lord Justice Buckley in Bisgood versus Henderson's Transvaal Estates Limited observed, I quote, "The purpose of the memorandum and the articles is to define the position of the shareholder as a shareholder, not to bind him in his capacity as an individual." In C. Duraiswamy Iyengar versus United India Life Assurance Company, the Madras High Court was of the opinion that a third person who purports to have rights against the company would be precluded from relying on the articles as a basis of his claim and must prove a special contract outside the articles. However, in some cases, the articles may create an implied contract between the company and a third person. Where, for example, on the basis of a clause in the articles, a person is employed to serve the company in some capacity, such as a director, and he accepts the office, the terms of the articles are encompassed in and form a part of the contract between the company and the director. Articles do not themselves form a contract, but they are the source of the terms upon which the director is serving. Dear students, we now try and understand how far the Articles of Association are binding between the members. An important question that can be raised at this juncture is how far do the Articles of Association bind one member to another? Unfortunately, there is no clarity on this point. The law is yet to be settled. The Companies Act does not aim to settle the rights of the members inter se. It leaves these to be determined by the articles. Hence, the articles define the rights and liabilities of members. But whether those rights and liabilities can be enforced by one member against another is the moot point. Lord Herschel said in Welton versus Safri, and I quote, "It is quite true that articles constitute a contract between each member and the company, and that there is no contract in terms between individual members of the company. But the articles do not regulate their rights inter se. Such rights can only be enforced by or against a member through the company." Unquote. The memorandum and articles did not constitute a contract between members inter se, although they regulated their rights which could be enforced through the company, and that they only regulated the rights of the members qua members for the purpose of company law. Thus, in Khasi Ram versus Hanutmal, a member of a company who had a commercial dispute of a private nature with another member could not be compelled to refer the dispute to arbitration in terms of the company's articles. The court said articles do not affect or regulate the rights arising out of a commercial contract with which the members have no concern, rights completely outside the company's relationship. It follows that the extent to which the articles seek to regulate the rights of shareholders as shareholders can be directly enforced by one member against another member without joining the company as a party. The case of Rayfields versus Hans lends support to this conclusion. The facts of this case are: the plaintiff was a shareholder in a company. Under Clause 11 of the company's articles, shareholders were required to inform the directors of their intention to transfer their shares in the company. It also provided that the directors will take the said shares equally between them at fair value. In accordance with this provision, the plaintiff informed the directors of their intention to sell their shares. The directors contended that they were not bound to take and pay for the plaintiff's shares. The articles, they said, could impose no such obligation upon them in their capacity as directors. This argument was not accepted by the court. By treating the directors as members, the directors were compelled to take the plaintiff's shares at a fair value. It was not deemed necessary that for the plaintiff to succeed in his action, he should join the company as a party. Dear students, we shall now try and understand how the Articles of Association can be altered. The company has an inherent right to amend its Articles of Association. The right to alter or add to the articles is expressly conferred by Section 14, which states that a company may alter its articles as often as required by passing a special resolution only. A copy of the special resolution authorizing the alteration, together with a printed copy of the altered articles, must be filed with the registrar within 30 days of passing the said resolution. The alteration will be effective from the date of registration by the registrar. It is to be observed that the power to alter the articles is a statutory power and cannot be taken away in any way. A company cannot deprive itself of this statutory right either by inserting a clause in the articles or by a contract with anyone. This was observed in the case of Andrews versus Gas Meter Company. Dear students, we shall now try and understand what are the limitations on the alteration of the Articles of Association. We have to remember that though the company has complete freedom to alter the clauses of the Articles of Association, it is subject to certain limitations. The limitations are: number one, the alteration must not be inconsistent with the provisions of the Companies Act or any other statute. Thus, a company cannot alter its articles so as to exclude or limit the rights of its shareholders to present a petition for winding up of the company, because this right is conferred on them by Section 272, Clause 1, Subclause C. To cite another example, the alteration cannot be made so as to increase the liability of any member without his or her written consent, for it shall be contrary to the provisions of the Company Act. However, it is possible that the articles may impose on the company conditions stricter than those provided under the law. For example, they may provide that a resolution should be passed by a special majority when the Act requires it to be passed by an ordinary majority. Similarly, the articles may provide that all the directors would be liable to retire by rotation when the Act provides that in the case of private company, all the directors can be permanent, and in the case of public company, 1/3 of the total number of directors can be permanent. Second, the alteration must not be inconsistent with the conditions contained in the Memorandum of Association. The articles are subject to the Memorandum of Association and so must not override the Memorandum of Association. As such, they cannot be altered so as to give powers which are not given by the Memorandum of Association. Third, alteration in breach of contract. Sometimes an alteration of the articles may result in a breach of contract with an outsider. In such a situation, the company may change the articles, but it will have to pay damages for breach of contract. In Southern Foundries Limited versus Shirlaw, the facts of the case are Mr. Shirlaw had been the managing director of Southern Foundries Limited, which was in the business of iron castings. But then another company called Federated Foundries Limited took over the business. The new owners had altered Article 8 of the Southern Foundries Limited's constitution, empowering 2 directors and the secretary to remove any director. Then they acted on it by sacking Mr. Shirlaw. Mr. Shirlaw's contract, signed in 1933, stated that he was to remain in the post for 10 years. Mr. Shirlaw sued the company for breach of contract, claiming for an injunction to stay in the office or substantial damages. The House of Lords held that since the contract between Mr. Shirlaw and Southern Foundries provided that his term of employment was for 10 years, his removal before the expiry of that term, the removal was facilitated by changing the Articles of Association. This resulted in a breach of contract for which the employer was answerable in damages. We have to also remember that the court may restrain an alteration of Articles of Association where the damage caused by such alteration cannot be adequately compensated in terms of money. In British Murex Syndicate Limited versus Alperton Rubber Company, an agreement provided that so long as the plaintiff syndicate held 5,000 shares in the defendant company, it should have the right of nominating 2 directors to the board of the defendant company. A provision to the same effect was contained in Article 88 of the defendant company's articles. The plaintiff syndicate nominated 2 directors whom the defendant company refused to accept. An attempt was then made to cancel Article 88, but an injunction was granted to restrain it. The learned judge observed that the contract clearly involved as one of its terms that the Article 88 was not to be altered. That is, that the plaintiff syndicate, so long as it held the stipulated number of shares, was to have a perpetual right of nominating 2 directors of the company. Dear students, it is however important to note that in case a person accepts the appointment purely on the terms of the articles, the alteration shall be valid and binding upon such a person. For example, in C. Chettiar versus Krishna Iyengar, the articles provided salary at the rate of 250 per month for the company's secretary. The post was accepted by the plaintiff, and in the specific agreement with him, the articles were referred to show the terms of the contract. Later on, the company changed the articles so as to reduce the secretary's pay to Rs 25 per month. The alteration was held to be valid and operative. It was stated that anyone accepting an appointment purely on the terms of the articles takes the risk of those terms being altered. Next, we have to remember that the alteration must not constitute a fraud on the minority. Alteration would be liable to be impeached if the effect of it were to defraud or oppress the minority. This principle was laid down in the case of Minier versus Hooper's Telegraph Works. In this case, the majority of the members of Company A were also the members of Company B. At a meeting of Company A, they passed a resolution to compromise an action against Company B in a manner alleged to be favorable to Company B but unfavorable to Company A. On an action by the minority shareholders of Company A, the resolution was held invalid and the compromise was set aside. The court observed that it would be a shocking thing if that could be done because the majority have put something into their pockets at the expense of the minority. Similarly, the court will certainly intervene if the majority pass a resolution sanctioning a sale of the company's property to themselves at an undervalue. The next point to remember is that the alteration must be bona fide for the benefit of the company as a whole. Alteration shall not be valid if it has been made for the benefit of an aggressive or fraudulent majority. Thus, in Brown versus British Abrasive Wheel Company, certain shareholders held 98% of the company's shares. The company passed a special resolution that a shareholder, upon the request of holders of 90% of the issued shares, shall be bound to sell and transfer his shares to the nominee of such holders at a fair value. It was held that the alteration was not for the benefit of the company as a whole, but for the benefit of the majority, and an injunction was granted restraining the company from carrying on the resolution. On the other hand, alteration made bona fide in the interest of the company shall be valid even if it is likely to adversely affect the personal interest of some of the members of the company. Thus, in Sidebottom versus Kershaw, Lessee and Company, the court upheld an alteration of the articles of a private company which authorized the directors to order any shareholder carrying on a competitive trade to that of the company to transfer his shares at a fair value to the person nominated by the directors on the ground that the alteration was for the benefit of the company as a whole, individual hardship being irrelevant. The distinction between these two cases must, however, be noted. Whereas in the former case, the alteration was clearly for the benefit of an aggressive majority, in the latter case, it was not, because under the given circumstances, it would likewise have operated against the majority. Dear students, this is all with regard to Articles of Association. In this lecture, we have tried to understand what is meant by the Articles of Association. We have also tried to understand what is the binding force of the Articles of Association. We have also tried to understand what are the situations in which the Articles of Association can be altered and what are the limitations on the power to alter the Articles of Association. I hope you have understood the lecture fully. Stay blessed.